My name is Sivan Tumarkin, and I'm the co-founding partner of Sivan Tumarkin LLP, a national law firm. We focus on long-term disability. I strongly urge you to tune into this podcast. Eleanor, Stein, and myself, we're going to be talking about long-term disability, how to apply for it, how to deal with insurance companies when they're being difficult with you, how to get empowered, how to understand what your rights are, and most importantly, to understand that when things go sideways, there's somebody here for you, and you are going to be able to deal with it.
Hi, everybody. I am Dr. Ellie Stein, welcoming you to another edition of the Dr. Eleanor Stein podcast. My guest today is Sivan Tumarkin. He's going to share his experience about disability issues in Canada so that you can be more successful with disability claims. Mr. Tumarkin is the national co-managing partner of Sivan Tumarkin LLP, and he leads the firm's disability and personal injury practice. He's widely respected for helping individuals whose long-term disability benefits have been denied or cut off. So if you're in that position, listen up. He represents and advises clients in every province except Quebec. He's frequently retained in complex, high-stakes cases where insurance dispute disability or compensation. What is unique about Sivan is that before co-founding the firm, he practiced for the other side. He worked at a leading insurance defense firm, acting for insurance companies and large corporations. From this experience, he understands how insurers assess and deny claims and uses that insight to help his clients. Sivan appears on the Disability Law Show, which can be accessed on TV, radio, and online. The show's goal is to educate people about myths surrounding disability law so that listeners can be more successful with their claims. Before I introduce Sivan, a little bit about my background. So for the entirety of my 25 years in medical practice in Calgary, Alberta, Canada, working with people with complex chronic diseases, I encountered disability issues on a daily basis. Most people with complex chronic diseases are unable to work, and many apply for disability supports. People living with ME, CFS, fibromyalgia, long COVID, and chronic pain are disproportionately denied or cut off from long-term disability, not because they aren't disabled, but because their conditions don't fit the narrow, outdated models of disability. With no single gold standard tests, insurers frequently dismiss legitimate claims, force claimants into rehab programs they can't complete due to post-exertional malaise, and then label them as non-compliant when they have to drop out of the programs because of worsening health. So I am thrilled to have Sivan here to walk us through the whole process from start to finish about applying for disability claims in Canada. And at some point, I'm going to ask him, I'm very aware that not all of you live in Canada, and I'm sure there's probably some commonalities to disability issues in other countries. So Sivan, welcome to the podcast.
Thank you. It's a pleasure to be here.
I'd like to start with the big picture. Can you just explain for people who may just be thinking about disability for the first time, what is disability insurance and how does it work?
So we have various types of disability insurance. There is government disability. In Canada, we have provincial disability programs. We have a federal disability program. And of course, we have private insurance. Now, private insurance, you have that by way of short-term disability and or long-term disability. That can be either through a private plan that you purchase, the way you purchase car insurance, automobile insurance, the typical type of insurance, travel insurance, house insurance. But you can also have it, and in fact, in most cases, you have it through work, external health benefits, etc. The types of insurance that you have available to you may have different tests for you to qualify for that insurance. The commonality between them is that as a result of your constellation of symptoms, functional limitations, illness or injury, combination of those, you're unable to carry out the duties of your employment. So depending on which insurance we are looking at, the tests could be different. But again, ultimately, the question is, can you do your job? Can you do the tasks of your employment?
Okay, that's really helpful. What's the application process? So someone becomes ill, say most recently they've got long COVID, they realize after some months pass they just can't do their job anymore. They maybe are lucky enough to work for a company that has a disability insurance program. What do they do next?
So the first thing you need to do before you even ask for the application itself, I'll talk about that in a moment, is speak with your doctor or doctors, whoever's treating you. And that could be your family doctor. It could be a psychologist. It could be a specialist. It depends on what it is that you are dealing with. But you need to speak with whoever your treatment providers are. Explain to them the situation. Tell them that you're having difficulty at work because of your symptoms. Excuse me. And make sure that you're on the same page. If you think you need time off to recover, to undergo treatments, you're going to need their support. And the reason is this, because when you apply for disability, and this is the same for disability through the government or through private insurance, let's focus on private insurance for now, short-term and long-term disability, you're going to have to fill out certain forms. You're going to get those forms either by contacting your insurance company directly, the insurance company that is providing you with this coverage, or if this is insurance through work, you can speak with your HR person, with the owner of the company, whatever the situation may be. But you're going to have to get your hands on the application itself. The application is going to generally have three parts. There's going to be a part for you to fill out basic information, your name, your address, you're describing the issues of disability. There's going to be a really important section for your doctor to fill out. Very important. And this is where the communication between you and your doctor is absolutely critical here, because what they put down is what the insurance company is going to focus on. And then typically there is a section there for the employer to fill out some information. So the initial step you're going to take is you're going to speak with your doctors, make sure you're on the same page, that you need time off. Second step is you're going to make sure you get this application and make sure it's filled out as accurately, as truthfully, and correctly as possible.
Do you have any tips about filling out that form? So people often asked me as a physician, what should there's with these diseases, it's not, oh, my leg is broken, I can't walk. It's not that straightforward. So it's sometimes nuanced. And I think sometimes people get themselves into trouble right off the get-go because they haven't really filled out the form in such a way that the insurance company can clearly or accurately assess it.
You're absolutely correct. And in fact, I've seen applications rejected because of quote unquote insufficient documentation, rationale, you're not disabled enough. And when I've looked at the applications, a lot of times it's because there was not enough information or correct information put in there. So let me break this down. The insurance company is interested in understanding really one thing. Are you able to work? Are you able to do your job? So if you or your doctor simply say, this person is disabled, I am disabled, that's not enough. You need to explain what the issue is. But the issue is not as simple as stating, I have a chronic condition. I have long COVID. That's still not enough. You would think it should be. You'd think that some of these conditions, it should be clear that there are symptoms associated with these conditions. But again, that's not enough. You need to be specific as to the symptoms and the functional limitations. That's the key. What exactly is it about your job that you can't do because of what symptoms? Are you having memory issues? Are you having an issue getting out of bed? You have no energy. Are you having, is there a phobia? Is there a lack of energy? There's a myriad of symptoms. So the key is to be as specific as you can be about what is disabling you and specifically what is preventing you from doing your job. And it's the same for the doctor. That's why I say that you have to be in close communication with your doctor, and you have to speak with them about the application. And incidentally, over the years, I've had many different practitioners contact me, psychiatrists, psychologists, orthopedic surgeons, chronic pain doctors, asking me how should they fill the application. And the one thing I don't do is I don't tell them, here's what you say. I tell them, here's what the insurance company is looking for. This is what they need to understand. They need to understand how your patient is unable, why they're unable to perform the tasks of their employment. So that's what you need to do. You need to be specific. You don't need to overstate anything. You don't need to exaggerate. In fact, those two things, chances are the insurance company will know this because they're going to be reviewing the medical documents. So you need to be as truthful as you can and as specific as you can, specifically with respect to functional limitations.
To accompany the application, I used to advise people to really keep track of their symptoms. So part of my program was to have daily charting. And people really didn't like it. It was not the favorite part of what I offered. But when it came to disability, they were so grateful that they maybe had a few months of charting that showed every single day the severity of their symptoms and also the variability. So with these complex chronic diseases, it's not just that you're blind and you can never see and therefore you can't work, I don't know, as an artist or something. It's that some days you might be able to do a little bit more, but then you hit some post-exertional malaise and now you're laid up in bed for a few days. So is there a way that you recommend to people to kind of try to communicate not only the severity and the functional limitation, but also the variability of symptoms?
I am so happy that you gave that advice. It's the same advice that we give to everyone. And frankly, we have charts that we prepare for people that they can use. But really, you can do this on your phone. I mean, our phones are computers now. You can have the notes section. And you are completely right that you need to track this because you're not going to remember how you felt necessarily a week ago or a month ago, let alone a year ago. Let me give you an example, a very straightforward example that just actually happened fairly recently with one of my clients. And we're going to get into this in terms of how you communicate with adjusters. But I just love to speak with you by phone. And of course, these conversations are recorded and they record what you say. And, they ask this individual, or my client, how do you feel? And my client says, I feel great. Well, the adjuster is going to write down this person is feeling great. And if they have enough of those greats on record, well, guess what? They're going to say, well, seems like you've been feeling great for quite a while. How about we have you try to go back to work? Now, luckily, this individual here, when this came up, said, "Well, why don't we look back at my notes, and you will see that those grades happened generally in the morning, just when I woke up. I recorded that within an hour I had to go back to bed, and so we have these records. And what's key, and this is really, really crucial for people to understand, um, these are contemporaneous records. When you keep this
Ah, okay. Meaning at the time, like not a month later trying to remember
correct.
what happened on that day. Yeah.
Exactly, exactly. Because insurance companies, again, they will say, well, you're saying that you did not feel well 4 weeks ago. How do you know that? It's convenient for you to say, well, no, I have a diary. Now, your notes, you may need to provide those to the insurer, but the point is, by creating this record in real time, you are creating essentially a paper trail that you have complete control over. That gives you enormous power when the insurance company potentially down the road says, well, we're questioning whether or not you can do this or that. You seem to be okay. You can look back at your notes and you can say, well, I have documents. And that's something they can never challenge you on. They can try to challenge you, but they can't. So my point is, you are completely correct. I have had people say, I, I don't like doing that. It's tough, but it is necessary, much like taking medications or doing treatments.
Okay. That's really helpful. What if your healthcare professional maybe doesn't keep great records or is rushed? I'm sure that would never happen to any of you listening, but your doctor is rushed and they just really don't have the skill or the time or the expertise to fill out the form correctly. Is there any way a patient can assist them or I don't know, like what I would do is I would have my patients look at the doctor's form on a separate piece of paper or on their computer, write what they think the accurate answers would be so that the doctor, of course, can be guided by that or not, but at least had a framework. So they're like, it's hard for doctors to know you as well as you know yourself.
You are completely right. And here's a piece of advice. And again, this ties back to keeping your own records, which, by the way, may seem overwhelming, but it's not. We're talking about 5 minutes a day, maybe 10 minutes if you're doing it several times a day. It doesn't take a long, because you're jotting the notes to yourself. And as part of those notes, you should also record the times that you go to the doctor, and keep notes, again, short form, about what you told the doctor. And here's why that's important, because if you need your doctor to provide a letter, provide a report, fill out a form, there's nothing wrong with you saying, asking the doctor to do so, and then saying, let me give you a copy of my notes, or here's a summary of my notes, which includes, by the way, the times that I visited you. By doing that, you're not telling the doctor what to put down, but you're providing context, because your doctor is not privy to your own notes. And listen, I'm not saying give your doctor 50 pages, but if you provide your doctor with a few pages of neatly typed bullet form notes about what's been happening in the last little while, and encompassing some of the appointments you had with him or her, or maybe another specialist, that I think can help tremendously. And yes, I've come across many different practitioners, some of which have more time to invest, and some of which it's difficult to get them. But it's rare to find a practitioner that's not sympathetic or empathetic. It's just that doctors are extremely busy.
And
So I do tell my clients, look, give your doctor a break. Help them as much as possible. Don't be demanding, but just help them help you.
okay. I just wanted to get a sense, I would recommend that, but whether that was kind of a legitimate or helpful advice.
For sure. What it is 100% legitimate.
So most of the people listening to this podcast are going to be people with what we call hidden or invisible disabilities, for which there's no gold standard test, despite millions of dollars of research, people working feverishly to try to get one. Are they in a more difficult position or a different position? Or does it really still come down to the assessment of function, and the diagnosis shouldn't be that important?
So it really depends who you're asking. If you're asking the insurance company, they'll tell you that they are as objective as they can be. And they tell you that they look at everything the same way, etc. It's not true. When we're talking about an insurance company, what are we talking about? We're talking about an individual person, an adjuster, who may come from a different background than you, may have different education, and these adjusters themselves perhaps may have different ways of doing things depending on the insurance company. Um, People who have, let's call it, quote unquote, invisible illnesses or injuries. And for the sake of just making things simple, I typically say, can you see depression on an MRI? And listen, I'm sure there can be neurologists here on the show that will tell us you can see some changes here and there on a CT scan. I'm not talking about that. Can you see the fact that I am sad, that I am unable to get out of bed? Medicine has limitations. Insurance companies are very aware of this. In fact, judges have said this in judgments in these kinds of cases throughout the country. But you still have insurance companies who are skeptical, and I understand why they're skeptical. Not everybody necessarily who applies for disability is either disabled or as disabled as they say. That said, when I speak with somebody, it's not difficult for me to assess whether or not what they're telling me is the truth. And the same goes for insurance companies. The problem is that insurance companies, they're built or they're designed to make a profit. I'm not against that. I understand the principle behind it, but it's the way they go about it. And the problem with individuals that have what's called invisible injuries or illnesses is that they feel maligned. They feel like they are somehow asking for something they shouldn't. They're being put on the spot. They're being told, prove this or else. And it's not fair. And insurance companies understand this. And so they're playing a numbers game. If they can sufficiently target you, if they can sufficiently tell you that you have no case or you haven't proven your case, a certain number of those individuals will not pursue their claim for disability. They'll wipe.
They'll give up.
It's a numbers game. It's much more difficult to do this with somebody who has a broken back. But I can tell you unequivocally that individuals with, let's call these, again, invisible illnesses or injuries, their cases are not only as strong for these kinds of claims as individuals with quote unquote objective medical findings. But sometimes it's even stronger. And the reason is because it comes down to credibility. If you tell me you're disabled, you have a diary, we have your treatment providers telling us this. We may even have other individuals, colleagues that can potentially provide insight, family members. What does the insurance company have? Who do they have to contradict you? So that's why credibility is so important in these kinds of cases. But these kinds of cases can be as strong, if not stronger, than the objective kinds. I use objective in quotes here.
Yeah, that's so important. I can't count the number of times people would say, I'm not going to apply for disability because I've heard nobody with FM is ever accepted. And I would say, no, 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 start keeping your diary, start doing your charting. Let's start building, let's see what you can and can't do, and then make a decision whether you might be eligible.
People, one of the common questions I get is, does this qualify? Does this qualify? Is this condition? And I tell them, look, unless you have a policy, and those are very rare policies, a policy that says that the only way you qualify is if you had an accident. So accident type policies, or you're injured because of an accident. If you have a standard long-term disability policy, all I need to know is, can you do your job? Can you do the essential tasks of your own occupation? And do your doctor or doctors agree? If that's the case, apply. What is the worst thing that can happen? The insurance company says no. That happens. Let me take a look. Why not? I had an individual come to me a few years back, and it was a neurological issue, but it was a very complex one. And you would think, on its face, how could the insurance company deny that claim? Well, they had 12 reasons. I call them excuses, but 12 reasons for denial. I can tell you that claim settled with the insurer within less than a year for a significant sum. Because what happened was, as soon as we got involved, that claim went to a different department in the insurance company. They assessed the risk, because for them, it's all numbers. They understood that they could get hit much harder down the road, and they ended up resolving it. So never, ever, if you're disabled, you feel you can't work, your doctors agree, never, ever simply walk away from this claim. These policies were paid for. You're not asking for charity. People don't understand. You're not asking for charity. These insurance companies were paid for this.
Right. That's such good advice. When people feel with these hidden disabilities that they have to prove their claim, and sometimes they do. So for almost 25 years, I ran a testing team in Calgary, and we did all these objective tests. Mostly that worked. So mostly the insurance company, you talk about a mosaic of evidence, so that just really kind of overwhelmed them with evidence. But sometimes still the insurance company would say, oh, that particular test isn't widely accepted. So then they would deny that the test was valid. Yeah, I don't know if you can say anything about that situation.
Yeah. So we do come across that. I have a friend who's a chronic pain doctor. And we see this a lot in cases like fibromyalgia, for example, where I remember when I was a defense lawyer decades ago, I took the position back then too. I was a young lawyer. I was working for insurance companies, and I would discount any tests that they threw my way. Remember this. The fact that the insurance company says that they're discounting this test is irrelevant. And here's the reason why. So long as it's been administrated correctly, so long as, even if there's controversy about the test, even if, okay, let's presuppose that. I don't care what the insurance company's views are. I care what happens if this ever went in front of a judge. And by the way, as a sideline here, very, very few of these cases ever end up in court before a judge, for one reason only, in my opinion. And it's anecdotal too, but I can tell you, insurance companies are terrified of bad precedent. That's why you haven't seen yet a long COVID case. They do not want to open Pandora's box. So let me put this to you. Let's say that there is a test that you administer that they say is not objective or is problematic or whatever. They're taking issue. Let's say that particular case went to court. Let's say a judge says, I accept that. Suddenly, the insurance company has to reverse course on so many other cases. You see, people don't understand, practitioners do, how much leverage the regular individual, the regular person has against insurance companies. These insurance companies, it's mostly a mirage that they have all this power. People don't understand how much power they actually have. These insurance companies, you can Google this, every time there is a decision that affects them, it reverberates throughout the insurance industry. How do I know? Because I have a lot of defense friends. I have people who work for the insurance industry, and they lament every time there is a decision. On the other side of the country, there's the butterfly effect. Suddenly, all the insurance companies are rattled.
That's really, really interesting because I think most people feel totally powerless. They feel like it's a David and Goliath situation, right? And they're David and Goliath is huge and well-funded, and there's no way they can fight it.
You know, I love that analogy. In fact, I use that on my shows. I always say, you are David. Absolutely you. Who won that battle?
Right.
You just have to stand your ground. And the thing is this, most people, this is what often bothers me about insurers. They understand the predicament these individuals are in. So there is a psychological element to it, let alone the physical one, but there is also the financial one. The amount of stress people undergo internally within their family, not to mention the actual illness or injury or whatever they're dealing with. And these insurance companies know this. The system is designed to apply pressure so that most people will walk away. If you understand that you have rights, when I speak with individuals, one of the key things that they take away from it most of the time is, I can do this. I am actually entitled to this, because there's a gaslighting that goes on where the insurance company makes you think, not only do you not have a case, but how dare you even make a claim? And that's unfortunate.
Right.
It's just the way the system is. But yeah, no, remember, yes, you are David, but David won that battle.
Right. That's often forgotten. Thank you. One of the processes many people are asked to go through in getting the process of the claim, whether it's going to be accepted or not, is an IME, independent medical exam. Where if you can explain what that is, and I always looked at them with a heavy heart, but I'll let you explain why. And is there a way people can approach those assessments better, let's say?
Absolutely. I often get panicked calls about that. Let's break this down for anyone who's listening and doesn't know what an IME is. It stands for Independent Medical Examination. These things are anything but independent.
I'm glad to hear you say that, because that's my opinion, but I thought better coming from you than from me.
I've gotten flack for saying this so many times from doctors. And look, I am not suggesting that the individuals who are performing these assessments are somehow crooked or bad doctors or assessors. But here's here's what you need to understand, and then you'll see where I'm coming from. The insurance company selects the assessor. The insurance company pays the assessor. The insurance company instructs the assessor. The insurance company is hoping that the opinion of the assessor will help it stop benefits or deny benefits. And from the assessor's standpoint, if they do that, if they help the insurance company, well, guess what the insurance company is going to do? They're going to send them more clients. These assessments cost thousands of dollars. I've had situations, and I've had doctor friends, frankly, that have done some of these assessments, and they will tell me that at the height, they could perform 4, 5, 6 of these assessments a day, usually at anywhere from $2,000 to up to $10,000 a piece. Imagine how much money a lot of these practitioners are getting. So, I understand from a human nature standpoint that these assessors will try to help the insurance company. Now, what do you do? Under most LTD policies, in fact, any LTD policy I've seen, you do have an obligation to attend one of these if the insurance company wants you to. Let's say you go, you want to know how to act, what to do. It's really simple. You need to be honest. You need to go with the flow. Do not be confrontational, because the assessor will record the confrontation. You need to be as calm as you can be, which is, I know, a big ask, because you're essentially walking into the lion's den in a way. But you need to go through the process. You need to do everything you can. Don't exaggerate. Don't understate. Do whatever you can. There's going to be an opinion generated by the assessor. The insurance company is either going to see that opinion favorably to them or not. Sometimes these backfire on insurance companies. I've had assessors who have completely verified everything my client has said. But sometimes the assessor comes back and says, no, this person is either not disabled or they're much better, they can go back to work. And then people obviously get freaked out. And I understand why, because the insurance company now says, well, based on this assessment, we are going to start you on a return to work program. We're going to end your benefits. So here's what you do. You ask for a copy of it, of the opinion, of the assessment, of the report. You give that to your treatment provider, and you ask them to look at it and to discuss it with them. And you have them provide a counter, let's say, report. Doesn't have to be long, but something that, answers any criticisms or anything that doesn't accord with reality that this assessor has done. And you provide that to the insurance company. That may not stop the insurance company from stopping your benefits, but I can tell you right now, if I was a betting man and I'm going in front of a judge and I'm presenting the judge with your treating doctor, their opinion, and the insurance company's assessor, whom we usually call a hired gun, if you were the judge, whose side would you fall on? The hired guns or the treatment providers? I can tell you, I would love those kinds of odds in Vegas. And insurance companies know this, by the way. It's just that they're trying to utilize anything they can, and IMEs are one of those tools that they use. But I wouldn't be too worried about those. I really wouldn't.
Okay. What maybe the next step is someone's applied and they're turned down, or they've been on disability for a while and now they've been reassessed and told their benefits are going to end. What should someone do at that point?
Okay. Let's deal with the first scenario.
Sure.
You've applied, and that can be LTD or STD, right? For short-term disability too. You can't go back to work at this point. Your doctors agree. But for any number of reasons, call them excuses, the insurance company turns you down. The insurance company will give you an option. They'll tell you you can appeal this. You can provide more information. Some people take that as, oh, okay, there is a process here where I can persuade the insurance company that they made a mistake. You need to understand that for the most part, these appeals are internal. There's no third party on the outside. There are some exceptions, but I'm talking about the vast majority. You are essentially applying to the same entity, the same company that denied you in the first place. The chances of you getting a reversal, getting an approval here are very low. I have asked many, many times various insurers to provide their statistics on how many of these appeals are approved. Never once did I get a response back. Never once did they even acknowledge the request. That tells you something. But what people do is they will try to appeal those decisions. And the problem with those appeals is that they'll deny you, then they'll tell you can appeal again, deny again. And again, at some point, most people give up. Either that or they unfortunately run out the clock. You have 2 years from the date of the first time you were denied to start a legal claim against the insurance company for those benefits.
I did not know that. Just say that again. That is such an important
Yes.
piece of information.
Very important. And usually it's buried down at the end.
Yeah, I had no idea.
And this is across Canada. Again, Quebec being different, the laws are different in Quebec. But in the common law jurisdictions across all other areas in Canada, you have 2 years from the date you were first denied your disability claim to start a legal process, a legal claim. Call it a lawsuit, a legal claim, whatever. The legal procedure with a court must begin. Now, that sounds very scary. Let me tell you what happens internally for the insurance company and why that is such a powerful tool with insurers. And now I'm talking to you as somebody who used to work for them. As soon as a legal claim lands on the insurance company's desk, internally it goes to the litigation department. There is an adjuster that's appointed to deal with this claim now. They now have to assign this to a lawyer to defend. Either it's an in-house lawyer, somebody who works for them on salary, or an external lawyer like myself at a firm. Here's something that I can tell you is a fact. One thing and one thing only that insurance companies hate more than paying out, something they hate more than paying out a claim or paying an individual is paying their lawyers to defend these kinds of claims. As soon as the legal claim process starts and they have to assign a lawyer to deal with it, they are now bleeding money.
I get it.
It costs them money. You know how many times I had adjusters call me and tell me, Sivan, can we settle this claim? Like your bills are stacking up. So from the insurance company's perspective, they don't want people to understand this. But as soon as there's a lawyer or a law firm, the reality is it starts costing them money because they have to hire a lawyer, even if they have an internal lawyer in their in-house. That lawyer is on salary. There are only so many cases that lawyer can have. So it's really important. So do not appeal these decisions. Legal claims are a lot more powerful, but at the very least, get get advice. Don't just appeal without speaking to a lawyer first to understand the legal landscape. It's a little different. Let's go to the other side of the question.
Yeah.
When somebody's on disability, and let's say the person went through an IME, or let's say any other reason, the insurance company says, Eleanor, you've been on LTD for 2 years. We believe you're no longer disabled. We're going to cut off your benefits. They never do this retroactively. They never say, by the way, the last check you got or deposit was the last one. They'll give you a heads up. They'll say in August, in September, in March, they'll tell you when it's going to end. So at that point, they've now set a date. It's in their system. Again, they give you the opportunity to try and appeal that.
Right. So now when they deny you, now your 2-year clock is ticking? Is that,
yes,
or is that different?
Yeah.
Okay.
No. The 2 years ticking. Exactly.
Okay.
Now, most people try to convince the insurance company that they made a mistake. Again, meanwhile, they're getting paid up until that last deadline, that last date. And what I tell people is this: if the insurance company says to you that they're going to end your benefits in a month, in 2 months, whatever, and you know that you're still unable to work, and your doctors confirm that you're unable to work, guess what? The insurance company is in breach of the contract it has with you. They can't stop your benefits if you remain disabled, because under the policy, they can't. They're not allowed. So you have the ability now, again, to start a legal claim against them. They would love people not to know this. I've had cases where an insurance company has told a client of mine that a year from now, they believe the client should be okay. And so a year from now, they're going to cut them off. It's crazy. How do you know what's going to happen a year from now? And that was basically that was a high, I can't give too much information, but it was a high member of the military, from the Canadian military, that had significant psychological issues. And I can tell you, I couldn't believe what the insurance company did there, that they said that we think that with all the necessary help you're getting, within a year, you should be okay to go back to the military. That was a case where the insurance company paid very dearly.
Wow. What about the 2-year mark transition? So many people know for the first 2 years, you're approved for LTD. They say, as long as you're unable to work at your own profession, you're disabled, but then it changes to you could work at any profession. So many people with complex chronic diseases are told, oh, you could go work at McDonald's. You don't have to be, thinking deeply for that, or no offense to people who work at McDonald's and do amazing work. But they don't understand the post-exertional malaise. They don't understand the physical toll just anything like even standing still would take. Like they I think, don't understand the diseases themselves. And so they make, I'll say, excuses, to use your terminology. Well, you can't work because you can work because of this, that, or the other. That's just untrue.
You're completely right. So I'll break it down, and because this is a common misconception, and I really want to make sure people understand it. Under the majority of these policies, most of them, to qualify for long-term disability, you have to demonstrate, with the help of your doctor or doctors, that you cannot perform the essential tasks of your own occupation. That's for the first 2 years. So you're applying for it. You cannot perform not all the tasks, the essential tasks. You can't do your job, essentially. What happens at the 2-year mark? That's where many people get cut off, around that time or just before. And that's usually when you have the IMEs happen. And that's when people are getting sent to other assessors who assess your job history and your qualifications. Why? Because the insurance company is trying to figure out if they can cut off your benefits by arguing that you can do some other job, some other occupation. Here's what people don't know, or are not told. The test does change. It does become a bit more difficult to meet. But the test doesn't change from your own occupation to any occupation. It's from your own occupation to any occupation for which you are trained, for which you have experience, education, or training in. Those are the things. So it's very important to understand. They can't just place you in any other occupation. It's any occupation for which you have training, education, or experience. And some people will say, well, okay, My insurance company says that 20 years ago, I took some courses in computers, and so therefore I have some training or education, or maybe not experience, but training. No, no, this has to be looked pragmatically and practically. If you're a truck driver, you've been doing that for 30 years, 20 years, and back in high school or right after high school, you took a college course in computers, that does not make you a coder. They can't just plunk you in and do coding. Now, again, let's use a truck driver. Very, very difficult job. And I have friends who are truck drivers. Some of them make over $100,000. But you'd say that because it's not a quote unquote sophisticated job, well, why can't you work in McDonald's? I agree with you. No offense to anybody working there. I used to work there. So no offense. So what do we look at? We look at oftentimes commensurate income. What does that mean? If you can do a job at the 2-year mark that will pay you 60, 65, 70% of your pre-disability income, then the insurance company will likely argue that you can do some other occupation for which you are suited. It doesn't mean that it's the case, by the way. It's just an indicator. They're looking to see from a quantum standpoint, can you earn 2/3? Essentially, when you go on LTD, most LTD policies will pay you 2/3 of your pre-disability income. So really what they want to know is, can you work in a job that's going to pay you that amount? So we don't have to. But I can tell you almost without exception that anytime somebody's come to me and said, the insurance company has just said that they're ending my benefits at the 2-year mark because they say I can do these other 10 jobs and I can't. And here's why I can't. And oftentimes these are chronic type of illnesses. And the doctor says they can't. Unequivocally, the insurance company was wrong in those cases. And we were able to force them to pay because they can't do it. You're not allowed to force somebody off benefits because you argue that somehow they should be able to do some other job. It's not some other job. It's any occupation for which you are suited for by training, education, or experience.
Okay. What about this situation? Because I've had a few people fall into what I see as a potential trap. They say, well, if you can go back, like a graduated return to work, you can go back for this many hours a week and we're going to still pay you. Like the company will pay you for those few hours and we're going to support you. And so people think, oh, this is good. This is a collaborative situation. But inevitably what happens is, regardless of whether their health is improving, they're forced to continue working more and more until they inevitably crash and are off work. At that point, now, tell me if I'm right about this, the insurance company can pay you less because you weren't earning as much at the time you went off work. And so people have really suffered from that.
So it really does depend on the facts and the policy. Some policies will allow you to go back to a graduate return to work where they will supplement your income up to a certain amount. Some won't. So this is very policy specific. Okay. One of the things I failed to mention at the outset is this is a contractual relationship. You and the insurance company have a contract. That contract is the policy. And I tell people off the bat, whenever you go on short-term or long-term disability, get a copy of your policy so you have it in front of you. And understand what it says. I mean, even on our website, we have a lot of information about the terms used in these policies, but you need to understand that the insurance company is not allowed to do something that's not that they're not allowed to do under the policy. They have obligations under the policy, but you also have certain obligations and certain rights, just like them. You're right. I do see a lot of problems when individuals go back to work, but most of the problems that I see are not exactly what you described, although I have seen those. What I see most of the time is a person who says, I will do what I can. I will try to go back to work. And then they try to go back to work. They're there for a few days, maybe a few weeks, and they're not ready. And it's clear that they're not ready. And under most of these policies, we have a provision called a recurrence clause. Typically, it's anywhere from 4 to 6 months. You should be able to go back on LTD immediately if you're unable to go back. But insurance companies will oftentimes say, well, you haven't tried hard enough, or your doctor said that you were ready to go. So they'll put up barriers. But the reality is the insurance company must put you back on benefits if you've tried to go back to work and you were not successful. Those cases, by the way, are very strong cases because you have individuals who are legitimately trying to go back.
Yeah.
So credibility-wise, again, it's the reality of the situation that most people feel that they are powerless with these insurance companies, and it's not the case. People have so much more power than they realize. But insurance companies operate on this kind of gaslighting system. You have to be knowledgeable. You have to ask questions.
I wanted to ask you a little bit about what I'm going to call dirty tricks. You called it excuses. So things insurance companies do to try to basically get you to give up. One that I've encountered a lot is they say, we're not going to agree to your claim because you haven't seen a specialist. So in the case of people with complex chronic diseases, there is no specialty home. There is no specialist who, has been trained and certified by the college to work on these conditions. And so a lot of people get cut off because there is no specialist to see, or the wait list to see said specialist may be in another province that they can't afford to get to, or they can't get into for 2 years. Like there's just all of these barriers when the word specialist is introduced.
That's definitely something that I've seen. Ironically, um, uh, when you apply with that and the insurance company denies you, it's not as though they find somebody that can discount what you're saying. So they're saying, well, you haven't proven it, but they've also haven't disproven it. So it is ironic, and I think this goes to a broader issue, which is that insurance companies oftentimes deny claims on the basis of insufficient medical documentation.
Right.
Very, very common phrase you see. And people ask me, what does that mean? It's meaningless. Essentially, what they're saying is, we have not been satisfied. Well, that's a circular argument. I've given you a report or documentation from my doctor or doctors that tell you this is what they've observed, this is what they're seeing, this is what their opinion is. And by the way, sometimes you don't even have a diagnosis. Sometimes you have a constellation of symptoms you don't actually understand because we don't know everything. Insurance companies know this. So one of those tricks that you're mentioning, I call them, it's a dirty trick, it's a dirty excuse, is to keep gaslighting a person into thinking that they just have not proven their case. You know you're disabled, but you can't prove you're disabled. I mean, can you imagine how frustrating that is for an individual? I've seen people who break down. They don't. They say, what do they want from me? And some of them who have gone and hunted for purported specialists in different countries, because you're right, some things just aren't. Look, as long as you know you're disabled and you're treating doctors, it can be a family doctor. You can be in a remote area. You may not even have a family doctor. As long as you have a treatment practitioner that backs you up, you have a claim. If the insurance company says you don't, it's not going to be enough for them to say you haven't proven it. It's just not going to be. The threshold is a lot lower than you think. And by the way, this brings me to something else. If you don't mind, I want to mention this. This is another one of those things which I think is probably one of the dirtiest things in the industry. And I'm sure you've seen this many times. When they tell you that you are not totally disabled.
Right. That's almost every case.
Correct.
Almost every denial. Yeah.
But you know how many times I've had people call me and say, my doctor says don't even apply because no, you're not totally disabled. You can't do your job, but you're not totally disabled. This phrase, total disability, is there's a reason why they use the word total. It doesn't mean total in the colloquial sense that we use it, regular people. There is a legal definition to total. When I tell you I totaled my car, we both know what we're talking about. My car is one. When I total disability for people who are listening can mean an orthopedic surgeon who hurt his or her pinky finger and now can't operate. That's total disability. That person can play soccer. Remember, the test is, can you do the essential tasks of your occupation for the first 2 years? So oftentimes they will say you're not totally disabled. A person looks at the words totally. They'll assume it means being catatonic, being comatose. They'll say, yeah, I can't work, but I'm not totally disabled. So they're using the word totally to mislead. And that is an invention by the insurance industry. We've not been able to fix that. They simply insert that into everything. And it misleads a lot of practitioners as well, who, read it the way that a regular person does, which is total, which is 100% close to it. And
In bed. Yeah.
All right. Correct.
So really similar to that are cases where the person does the IME, they bust their butt, and what's not recorded in the IME is that for the next 2 months, they were in a post-exertional malaise flare and much less functional. Similarly, when insurance companies hire private detectives and they catch the person going out for coffee with their friend and they said, well, you were talking to your friend for half an hour, so you must be able to work. And again, not noting that maybe the person rested for 3 days before the coffee engagement and then for a couple days after. So I think post-exertional malaise for my community is such an important issue that's impossible to measure, impossible to prove, and is usually, we'll say, willfully ignored by the insurance companies. I don't know if you can say anything about those situations.
I'm going to go back to something you said, which is you
Okay.
have to keep a diary.
Okay.
You have to keep notes. Those are your records. Now, you do that, and you also mention exactly these symptoms. The fact that you're unable to get out of bed, anything you can, to your family doctor or to whoever is treating you. And the reason is this, again, this will make it hopefully into their notes. The more you tell them about this, the more it's recorded. Imagine that you have gone to your doctor regularly for the last couple of years, and the insurance company catches you, let's say, okay, that doing something, and you point not only to your diary, but they can see from the family doctor that you've been reporting these symptoms. The fact that you are completely dead, the next few days, that you can't do this, can't do that. To me, that is very powerful. And again, you can't stop the insurance company from pointing the finger and saying, aha, we caught you. But what's important is that you understand that it comes down to evidence and credibility. And ultimately, I can tell you, insurance companies don't have much credibility, not just with me or with you, but with the courts. So for the insurance company to say, oh yeah, the insurance company to say that, no, we had you do this and that. No, if you have a diary, if you have people around you that can potentially provide testimony if necessary, again, insurance companies will never even challenge that because they understand that that the evidence will be insurmountable for them, but they can take the finger.
Maybe two last questions. One is, how does what you've talked about differ if someone's applying for government disability, either provincial or federal?
Um, you're still going to have an application to go through. One thing you need to understand, we can do a podcast just on that, I can tell you.
Okay.
But these disability programs, for example, let's look at CPP disability. That oftentimes people come to us and say, do I have to apply for that? You don't have to apply for anything. But if you apply for a provincial or federal disability program and you get it, chances are your long-term disability policy will have an offset provision. It will mean that the insurance company can offset what you're getting from the government by paying you less. But here's the pro for this, the good thing. If the government deems you disabled, and in many cases the test is very similar with LTD, is can you do your work? Then it's going to be that much more difficult for the insurance company to say you're not disabled because the government has deemed you disabled.
Yeah.
However, on the other side, if the government says we don't think you're disabled, that doesn't mean that you're not disabled under the policy. You still are able to get benefits. So as to whether you apply for AISH or if you apply for ODSP in Ontario or other provincial programs or CPP disability, or by the way, workers' compensation,
Right.
there's consideration for all of these programs, but they do interact with each other. You do need to understand that. And you do need to understand that the LTD insurer or the benefits that you are entitled to them will be affected by what happens with those programs when you apply.
So maybe my last question, because you're a lawyer, when should people call a lawyer? How does it work? And how, especially, is the payment usually structured?
Um, I tell people that um, you should be able to call at any time when you feel you need to. That's the general answer. But I tell people, look, if you have any questions when you see the application and you don't know what to do with it or how to answer a question, then you call a lawyer. If one lawyer won't speak with you, I can tell you my team and I are my entire team is trained to answer these questions. We do these shows all the time. We do Facebook live streams because we want to make sure people have the information. But what I tell people is when you are dealing with the insurance company, if your spidey sense is tingling, if the insurance company is asking to do something or asking for information, sign this paper, do this, go there, and you have any hesitation, pick up the phone or email. Do not wait. Don't take your chances.
Okay.
People trust insurance companies. Don't trust insurance companies. You need them. We need them. I have insurance. Don't, when you have insurance, all you've done is you purchased a legal right to have them cover you in the event that you need them to cover you. You have not purchased a friend. They're not, the adjuster may be very friendly and nice, but they work for an entity that has an interest not to pay you for what you paid for. So, seek out. Now, it goes without saying that if you're denied your claim or you're cut off or told you're going to be cut off, immediately reach out. Immediately. Do not wait. Don't play around with the insurance companies. They're pros at this. Payment. I've seen all kinds. I can tell you that generally, the vast majority of firms, us included, we operate on a contingency basis. That means that you don't pay anything up front. If I tell you have a case, I'm willing to stake my time and the money that I have to invest in your case to be able to pursue your benefits. If I'm wrong for whatever reason, and I got $0, it's like a real estate agent that I made $0. The other thing I will say is, and this is important, I think, as well, is there are different law firms and different lawyers, just like you have different doctors, different engineers, architects. You get what you pay for, and that's important to understand too. There are good lawyers, bad lawyers, like you have in any industry. So you want to make sure that you do your research. You want to make sure you have somebody with reputation. And one last thing I'll say as a piece of advice. Insurance companies know who the players are. What I mean is they know who the lawyers are and who the law firms are. I can tell you that when I was working for insurance companies and when I got a claim to defend, the first thing I would do is turn over the claim to see who the law firm and the lawyer is. Based on that, based on the name, I advised my insurance client how much money to put aside for resolving this claim. How crazy is that? So
Yeah.
your claim quantum, even though it should not matter which lawyer you have or which law firm, the insurance company will put money aside depending on if they think you have a serious representation or if they think that your lawyer will negotiate a bad deal. They know this. They keep track of this. It's crazy.
That's fascinating. I want just ask you to end with top 3 tips. Like, what are the things you really want people to take away from this conversation?
I think I'll give you 3, but I'll start with the first most important one. You have, as an individual, and I've said this before in this podcast, a lot more power than you think. Do not be gaslighted. Do not think that because the insurance company says X, it has to be X, because oftentimes it's Y. So understand that you have that power, but you have to utilize, you have to be proactive, you have to stand up, or you have to at least reach out to somebody who can help you with it. That's number 1. The second thing is, make sure that you keep records for yourself. Make sure the diary we discussed, even conversations with adjusters, make sure that you keep a log for yourself and even verify by email with the adjuster, here's what we said on the phone, here's what we said. Make sure you have records. Don't rely on the insurance company. Certainly don't rely on your memory. Okay. And the third thing, which I think is really, really important, if anything happens, don't assume that you're alone in this, because there are thousands of people across the country who are dealing with very similar situations. And trust me, there's almost nothing now that people come to me about that I have not seen before. Everything can be dealt with. It's just that you want to make sure that you haven't waited too long such that your rights are compromised, because there are these limitation times. So those are the 3 things. But number 1, most importantly, you have a lot more power than you think you do.
Thank you. I love that message. Very lastly, how can people access your show? I've watched a few episodes. It's really, really helpful and informative. And how could they contact you or your firm if they have questions?
Thank you very much for that. Very simple website, disabilityrights.ca. We have a variety of websites, but disabilityrights.ca will not only give you access to all the shows, the TV shows, the radio shows. We have a website where we've had it for many years, where people post questions, and 24 hours a day, we have lawyers answering those questions. They're all free. It's one of my colleagues once said, when I told him, we're trying to even the playing field. And he says, no. He says, we're not trying to play. We're trying to tilt it in individuals' favor, because for far too long, it's been tilted to the insurer's side. So disabilityrights.ca, I would say, is the primary website, and happy to speak with anybody. I've had people that have been contacting me that for years have been helping them. And it's funny because they try to pay me and I say, I'm not interested. That's not the point. The point is for you to to understand what your rights are. Understand that the insurance companies, they can only do so much. And it's the power you give them that they have over you.
Thank you so much. This was really informative. I think people listening are, there's a lot of value they can take away, and hopefully they have a much clearer idea of what's involved. So thank you so much.
Thank you for having me.
Thanks for joining me on the Dr. Eleanor Stein podcast. I hope you are taking away new strategies and ideas to improve your health and a renewed sense of hope. Join me, Dr. Eleanor Stein, for our next episode. Can't wait? Check out my website for a wealth of free resources.